Should I enforce my patents? Hello, and welcome back to Invent Anything. In this episode, we'll be reviewing the crucial steps you'll need to consider thinking and taking of whether you should litigate your patents or not. It has to do with things like getting expert opinions and understanding your competitors. There's all sorts of different reasons, pros and cons, to why you might enforce your patents, and we'll weigh those. We'll even talk about the market impact considerations and all the things that might happen, like improving market share and getting new revenue streams, etc. So you don't want to miss this. So tune in and learn about whether or not I should enforce my patents. And this is John Cronin from Invent Anything.
Inventions keep the world spinning. From fire and the wheel to today's high tech, inventions power change. Turn your inventions into reality. Learn how to get your ideas to market. This is Invent Anything with John Cronin.
So today we're going to consider 6 different topics. The first topic is 10 things you might want to consider doing first. I think there's more than 10, but we can at least cover those off. And then we'll go to topic number 2, which is the top reasons for enforcing patents. And this is based upon lots of experience over 25, 26 years working with over 2,000 clients, many who have decided to litigate. We'll then go to topic number 3, which is, the reasons not to enforce your patents. You may be this, surprised that if you could enforce your patents, maybe you shouldn't. And then we'll talk about, in topic number 4, the market and business impact considerations of enforcing your patents. Once we've done that, we can then sort of talk about the business side of topic number 5, the ROI for enforcing your patents, the return on investment. And then we'll finish up with topic number 6, which I thought I would throw in just some other things, other thoughts that may impact your decision as to whether or not you should enforce your patents. So I really chose these 6 topics so you could really see the difference between the rationales between should I enforce my patents or not. And then they'll wrap up. Many times when I do podcasts, I sort of think about the audiences, and sometimes the audience are different. Here, really the primary audience is for those who are considering litigating their patents. Take small companies, for instance. Another audience may be understanding all this before you even decide what to do with your patents. I mean, maybe you're not yet litigating it, but you've been thinking about it. Another thing is for those who are creating patents in their companies, it's really great to know about the endpoint if you decide to take it about enforcing your patents. This is primarily very useful for investors as an audience because at some point they may have to use some of their investment dollars to litigate patents, and there's a fair amount of risk, so it's good to know about it. For management and for board members, it's critical to understand this topic because if you're brought with a decision, should the company enforce its patents, it's a very material discussion because it could lead to a lot of money. You could lose a lot of money as well as make a lot of money. And finally, for those who are maybe in patent litigation right now, you may find a number of things in this episode to be very, very useful to consider. So we could dig in. So coming up, we're going to do a deep dive into the essential steps for enforcing your patents. We'll discuss the top 10 actions you might want to take first. And then moving from there, we'll also explore compelling business reasons to enforce your patents, including strategies that might improve your market share, improve your position against competitors, and even ways to maybe develop and secure settlements. So in this episode, we'll have a lot of insights to unpack about whether or not you should enforce your patents. Let's jump right into topic number 1, the 10 things to do first. The first thing you should do if you're considering enforcing your patents is get an evidence of use. We have a podcast on that here in the series of Invent Anything, so you should follow that. Evidence of use means that you've taken the claims of your patent against the products that might be infringing and getting an expert opinion to essentially figure this out. Now, we would recommend a technical opinion through consulting practices like mine at IP Capital, or taking that technical assessment and moving it to a legal opinion about evidence of use. There's a technical side of this and a legal side of it. So that'd be the first thing that I'd do. The next thing I'd do is to get more expertise on damage assessments. So many times people decide to litigate and they start to get involved and they recognize that the damages are not going to be enough to even pay the cost of litigation. So getting a professional to help with valuation or damage assessment is really important. Another thing to do is to get a professional opinion on the prior art. Yeah, you had prior art to get your patent. Maybe something has happened since the patent issued was something that laid open earlier. Maybe there's patents, prior art that are in other countries in different languages. If you don't do this, this is going to be a real problem because almost always every defendant is going to do what's called an inter partes review, where they're actually going to look at your patents that you're enforcing against them, and they're going to spend some time and effort to essentially invalidate your patent, finding prior art. So I heavily advise that this is something you want to do. The fourth thing to consider is to get a financial estimate of how much it's going to cost and the tranches by which money has to go in. There's hiring an attorney on the front end. That might be 100, 150K to review the case. It's maybe $500,000 to Markman. Maybe it could be $1 million of expert opinions and fees and things like that. Many millions of dollars with attorneys. Most patent litigation is $3, $5, $10 million. So it's really important to understand the financial considerations that you might have to bear in order to litigate. Don't be dissuaded by that. There's other things that can happen to get financing, but I would suggest that as a fourth thing, you get a financial estimate. The fifth thing to do is to lock in the inventors of the patent, the named inventors. I mean, obviously your company owns the patents and they can litigate, they have standing, but you want to make sure that the inventor is on your side. So many times you go through this and then the named inventor or two are called in as witnesses and they're not very good on the witness stand, or they don't like the company anymore and they may say things that may actually hurt the case. So make sure you lock that in with the named inventors. Another thing to do is, and your attorney should do this, but to make sure you have clear title, because a lot of times the defendant may actually go after whether you have real standing in order to wage the litigation. So it's all about title. Make sure you have that locked down. Another thing you should do before you start litigation is, obviously you're going to go against the defendant. So please spend the time to study the defendant. Simple questions like, are they litigious as well? You think they'll counter sue? Do they have more money than you? Maybe they can outlast you in court. Another thing is to make sure that when you study the defendant, that you really get an understanding of not only their products, but maybe they have patents that they could counter assert. Understand them, because once you start a patent litigation, it's like waging war against the company. Another thing, which is really kind of interesting, I've learned this along the way, in a number of deals we've done, is you can literally take what patent or two you want to litigate, and then figure out through your counsel what venue, what city, where will it go? And then you can actually pull down on the web, and again, experts can help you with this, the judges that might take the case. And you can usually hone down into the 3 to 4 judges that are likely to take the case. Then you can read their case law. You can see how they've been, positioned in a patent litigation. You'll be surprised at the various subjectivity of the judges. So get that locked in. Another thing you want to do is to study whether or not the defendant can counter assert. This is vital because you could do a patent litigation to find out that you will be in a counter assertion that you'll have to defend yourself as well. And the last thing is, there's lots of things that can happen in a patent litigation. A lot has to do with the sophistication of the defendant. So you can find with a little bit of research, has the defendant been involved in other litigations? Are they sophisticated enough to buy patents from somebody else to counter assert? There's a lot of things that they can do. So studying them, once again, from whether or not they're sophisticated or not is very important. Well, those are 10 things you might consider to do first. There's plenty others. But let's get into the top reasons for enforcing patents in topic number 2. The first one is that if you learn that if a company is violating your patents, there's an obligation to some level of latches. You can't allow someone infringing your patents if and then not take them to court and wait then 7 or 8 years to do that until the market builds up. There's a requirement. Talk to your attorney about what those requirements are for you. That you want to be within the latch time of essentially litigating your patents. Another thing, on a reason for enforcing your patents, is to enhance market share, of course. Look, a patent's fundamental right is the ability to stop others from making, using, and selling, right? You have a patent, they may make, using, or selling in the country your patent is in. So now you have the opportunity to essentially litigate. And if you do, that should help you enhance market share, meaning you are claiming that market for yourself You have the right to stop others from entering into that market. And by definition, therefore, you're enhancing your market share. Another thing and a reason for enforcing is you make money. You might not be able to expand to the size of the market that's total based on your patents. So you may, through licensing, get others, to help expand that market so you can make money in the areas that you couldn't expand. I mean, maybe you don't have the brand, or maybe you don't have the money for marketing, etc. So by litigating your patents, you get access to that revenue. I mean, you could try licensing first, and if they decide not to license, then you can take them to litigation. A fourth reason for enforcing patents, or reasons to do this, is leveraging the market to stop copycats. If you have patents, certainly you could say patent pending on your product, and that could, wave some competitors off, but some copycats might not care. And by really starting an enforcement procedure, you may find that they stand down and want to settle. So stopping copycats. As a matter of fact, if you go against someone who's got your product, other copycats might decide to walk away from the market or call to get a license because they know you'll litigate. A fifth reason for enforcing patents is that through the process of getting subpoenas and litigation, you can learn a lot about your competitors. You can learn a lot about their customers, the R&D they're doing, etc. So believe it or not, some companies actually litigate against other companies for the sole reason of getting competitive information. If the market's that big and you have some patents to litigate, market information could be very valuable. Another reason for enforcing patents is it's a way of perfecting or executing a piece of an IP strategy. Look, you have ideas, they turn into inventions or provisionals, you get the patents on it. There's a whole bunch of different ways to make money through patents. One of the podcasts you should follow in the Invent Anything series is the 6 ways to make money through patents. One is litigation. So preserving your patent value through litigation is certainly one of the key strategic things that is done. One thing that some companies have done is to use patent litigation as a way of figuring out the know-how of their competitor, how they've been building what they build, and what is their manufacturing process, etc. An eighth reason for enforcing patents is leverage in the future. You see, once you start litigating, that could get to the point where other companies who might look to acquire you, it might trigger that said, my goodness, this company's got some good patents in this field. It's starting to litigate. Maybe we should buy them. I've actually seen companies acquire other companies to stop a litigation because they don't want a litigation to occur in their space. Certainly one of the things that happen to reasons for enforcing your patents is to enhance your company valuation. You see, if you have patents and they're worth a lot of money and you don't enforce them, then you can't get that value. By enforcing them, you can get that value and therefore add that valuation to your company. And the last one, I think, and there's many more, but the last one I'll touch on, a reason for enforcing patents is it's a legacy for the company for market dominance, meaning, you have a history of your company, the things that you do, somewhere along the way, you had to enforce your patents. Maybe it all settled out and maybe things are going your way, but you look back historically over the legacy of your company, it shows you as the brand, as the innovator, shows you as you're willing to take the patent system, and shows that you will then litigate as a way of sort of completing the legacy of being innovative and protecting your innovations. Well, coming up, we're going to talk about some other things. We're going to tackle the tough decisions behind patent enforcement. Should you decide to enforce your patents or not? That's what we're going to talk about. We're going to understand the possibilities of losing, the high cost, the exposure to countersuits. On the flip side, we'll talk about the market share you might get, the revenue streams. We'll explore how these decisions can actually impact your business. And we'll also talk about how this allows you to differentiate your product in the market and actually leverage your IP strategy. So we'll learn how to navigate this complex world. Should you or should you not litigate your patents? And we'll get right into that. So in topic number 3, we're going to talk about the top reasons for not enforcing your patents. Actually, when I decided to do this podcast, this is where I sort of started, and then I built backwards and around it to talk about these other rationales. But some of the reasons for not enforcing your patent, and as a matter of fact, I spent a lot of the time in my practice over the last 25, 26 years talking to early stage companies about enforcing their patents. And I'm one of the first that would say that you really shouldn't enforce your patents. There's a lot of reasons. One is you could lose. And that's not good because you've spent a lot of money. You may have to pay some kind of damages. then now your patents are not really usable. You see, when your patents are issued, they act as a deterrent. If you go to court and you lose, then they're no longer a deterrent. So the rationale would be you're getting the value of a deterrent if you don't litigate. Another reason for not enforcing your patents is number two, it's expensive. And I've seen so many companies, that decide to litigate their patents, and halfway through they can't afford to do it anymore. And so really one of those top things to do first, understand the financial implications, please do that. Another reason for not enforcing your patents is, as you enforce your patents, and depending upon how that goes, you may weaken your position regarding IP. I'm not saying that you're losing, but during the process, you may have the markman that may limit your claims. You may have 7 patents and whittle down at the end of the day to 1 patent and 1 claim. The thing gets changed. So through this process, your patents get weakened. And this is true of anybody that chooses to litigate the patent. The defendant will find reasons to weaken the value of your patent, from everything from kicking it out in the inter partes review, showing it as invalid, to weakening it down. And I've been involved in a number of very large litigations in the hundreds of millions and almost close to $1 billion. And I've seen this. This then would have the reason of why you need a much bigger portfolio generally with many more claims. So a fourth reason for not enforcing your patents is it exposes you to countersuits. You see, when you fire off a patent litigation against a company, if they have patents that they can assert against you, they will, because they want to balance off this imbalance that they have by being litigated against. They may actually go out and try to buy patents to litigate against you. That's happened quite a bit. So anyway, expect them to countersue you. Another reason for not enforcing your patents, literally, it creates an IP arms race. As soon as somebody in the market starts litigating, others do. I'm involved right now in an industry that's, I would call IP naive, meaning there's not a lot of patent litigations. And when we start to watch new patent litigations, it will create this whole news, position that people are litigating. And then others may decide that they may have to litigate to play. So watch out, you may start an IP arms race. Maybe you want to litigate because you're in an arms race, I don't know. A sixth reason for not enforcing patents is it reveals your trade secrets, because when the defendant wants to subpoena you for more information, they're going to be asking about certain aspects of how your patent claims were developed and how things work, etc. And you may have to, through the subpoena process, explain a lot of things that you didn't think you had to, exposing some of your trade secrets, like the ability of what happened in the patent prosecution, for instance, as to how the claims were limited. So even though that might not be a trade secret, because that can be learned through examination of the patent office's database, maybe the company that you're suing against hadn't done that yet. And so now you've got them involved to really understand the value of your patents. Another reason not to enforce your patents is, in today's world, this didn't happen circa 2000, say 20 or 2015, but you get this negative PR. In other words, all of a sudden you're called a patent troll because you're using your patents to win in the market versus cost and brand and speed to market and things like that. So there could be a lot of negative PR, and that backlash happens quite a bit. So it turns out in our day and age, when there's a patent litigation, you're almost automatically labeled as a patent troll, meaning that you can't make money any other way, that you're just using your patents. You don't have really good products. An eighth reason for not enforcing your patents is, and this is a good one. This is a really good one. You would never think this, but it's the division and diversion of your time. I learned this a long time ago when I was at IBM, when I was running their patent factory, and I learned, firsthand how litigation really got management all wound up, and all of a sudden they're focusing a lot of time and effort on it. So the idea of you litigating against someone will cause you a lot of time, and you may not recognize it. You're going to have to report on this at every level to the board because there's a lot of risk. So there's a lot of time and resources. Another reason not to enforce is, maybe you want to leverage your IP in the future for an M&A. If you litigate, as I said, you may weaken your patents. Therefore, your M&A possibilities may be weakened. And then the 10th and sort of final reason for not enforcing your patents is that you may leverage business relationships that you were trying to court. Because when you stop somebody, you try to stop somebody through patent litigation, a competitor, you're actually threatening their customers. Because if they lose, they might have to pull their product. And therefore, you're creating a market sort of bad set of relationships. So you really need to be thinking about that. It's pretty complex. So let's jump over to topic number 4, market and business impact considerations. You see, when you decide to litigate your patents and going through litigation of your patents, you're going to change the market dynamic a bit. One thing is the market's size and its growth potential. Maybe it is growing, maybe it's large. And one of the thoughts is that you should litigate, right? Because of the market's expanding. And there's no way that you can literally get the product out to all these markets. So enforcing your patents can help you get a good lucrative share of the expanding market. Another thing about market considerations is that if many competitors are infringing your product, your patents, and you're trying to sell your product, but many are infringing your patents, enforcement may actually be necessary to differentiate your products. If you have 10 copycats, who knows who's the real inventor? And the real inventor with patents should be making more money on their sales and margins. So it may be the requirement that you litigate to show that you were the innovator. A third reason for understanding the market and impact is that analyzing infringement is a way of kind of understanding your own market share, isn't it? If there's an unauthorized use of your patented technology in another product, that means that they're eroding your market share. And so for you to take time to understand who's violating your patents, therefore who's eroding your market position, that's important. So you kind of think about this if you're in a small company, a mid-sized company. What does marketing do? They try to find new ways, right, to essentially market the product. Well, maybe they should spend at least one day a month figuring out your patent position and is your market share eroding by not leveraging your patents. Another thing that happens in business consideration is you're deterring sort of future infringement. So enforcing patents can serve as a deterrent to potential infringers, of course, and signaling that you're vigilant, that you're going to enforce your patents because of your IP. So this can now actually help stop future infringement. If you're willing to litigate today, they may not be so willing to copy and infringe on your patents in the future. And a sixth reason for understanding the business impact and consideration is innovation leadership. Look, patents do give you the right to stop others from making, using, or selling. It's a governmental right. But the examiners gave you the patent, and they have no dog in the fight. They are claiming you are innovative because they allowed the patent, which now means that you're innovative, according to a third party, relative to your patents, which stop others to make, use, or selling. So now the thing is that you're legitimately the innovator. So in order to reinforce your brand, sometimes litigation is the only way to do it. Otherwise, it's just going to be a discussion in marketing, right? A seventh way to sort of think about, market considerations and business considerations is product differentiation. You can maintain your unique features in your products because they're patent protected. So it could be advisable to basically take your unique product features that you get your patents on and litigate as the way to maintain the uniqueness of your product features. In other words, they're copying you, and you need to stop them from copying. Another thing is, for market business considerations, is this actually could strengthen your sort of negotiation power. Maybe you're having customers, and some of your customers may be deciding to move to a competitor. By suing the competitor, that sends a signal to your customers that maybe they should be buying your products. It might strengthen your position. Also, your investors are kind of interested in investing in companies, and when they see a litigation going on, even though they don't like litigation, they maybe want to invest in the space, but they see this company that has litigated, so that may turn on a partnership or bargaining for investors. So there's a lot involved in this chess piece called patent litigation. Another thing about patent litigation as a business consideration is if you litigate, you're kind of enforcing your standards. If you sort of think about the cell phone technologies of 5G and 4G and 6G, et cetera, it's all about owning the standard. And believe me, all these cell phone companies try to patent like crazy their innovations under the standard. So when you enforce your patents, it's kind of like creating standards in the market that you own the standard. And a final market and business consideration is this allows you, believe it or not, to expand into new markets. You may have a patent that covers something in a particular market, but the claims could read in multiple markets, right? You can have a special material that you're going to use in the handle of an endoscope to stop germs with silver particles, but that same patent, which is putting silver particles in a polymer to stop germs growth, could be used in kitchenware. And you're not in the kitchenware space. So many times patents are written in multiple markets. I know when we do valuations, we value it in 2, 3, 4 markets. So your patents could be in markets that there's no way that you can go after. And so if you start to see someone using that technology in another market, litigating in that market is the way to get a position if you win in those other markets. Let's take a look at the last part. In our next discussion, we're going to be talking about ROI, getting money out of this, out of litigation. We're going to talk about how it justifies the things you may have to do for expenses and all that. We're also going to be talking about how it highlights that enforcing your patents makes your products maybe even more attractive, building better customer loyalty, how you can draw in investors, and ultimately boost companies' valuation. That's not all. We want to sort of end up talking about all sorts of different thoughts that come out of this. Not ROI, not should you or shouldn't you, just all the different things that may happen as a result of considering or doing patent litigation. So stay tuned. So let's talk about the return on investment for enforcing your patents. Well, one return of investment is winning justifies your whole IP strategy, right? You get patents and someone keeps saying, well, why are we getting all these patents? Well, at some point you may have to litigate or a license, but litigating basically tells you that you're executing your IP strategy, but even more importantly, that basically when you win, it's a way of justifying your IP strategy. Maybe after you win, you want to file even more patents. Another return on investment is that it produces for you revenues, and then it balances you in the market, right? Because now you're getting revenues through a settlement from a competitor. So now you're making more money, which you should if you have the patent rights and others are infringing. A third return on investment is enforcing your patents prevents competitors from using your inventions that then allows you to maintain market exclusivity. Well, this is great because that means you have premium pricing, higher profit margins, and really just greater market share. Hence the reason for the patent system, to spur innovation, to allow those that came first to get a benefit. In a fourth ROI for enforcing, the patent features can make your product very attractive as a way of differentiating marketing. You can literally put these features are patent protected and link to the litigation case, if you will, that others could see that you really own these and enforce them. A fifth interesting ROI for enforcing is once you litigate a patent and you win, to investors, that shows that you are a breed apart, that you can protect your innovations. Sometimes winning a patent litigation in a market means that you could win patent litigation in other markets or more winning in the same market. So sometimes you do a patent litigation enforcing against one competitor. If you win, you might have 5 to 10 other competitors to infringe, to litigate against. And investors would see that as a business opportunity. One of the things that's another ROI is the threat of enforcement really can drive competitors not to infringe. It's a way of stopping copycats. So if you actually start a litigation, you may find some competitors actually start to change their product. So it's really an ROI to win in the market that way. The seventh way to kind of get ROI for enforcing is enforcing the patents can give you a position as a leader in the innovation. Therefore, you become a leader in partnerships and joint ventures and strategic alliances. I've seen this many times, that because of a win in a litigation, a large company, all of a sudden that may want to do acquisitions in the space, will actually pick you out as the one to go after for acquisition first. Why not? Because if you won, why would they buy a competitor that could be infringing, right? It would make it even worse for them to take a bigger market step with an infringing competitor. Another ROI for enforcing is protecting your brand. If you claim you're the innovator and you've got the patents, and you enforce and win, there is no better way to claim that brand that you are the innovator. A ninth way of getting an ROI for enforcing is basically improving the company's valuation through enforcing patents. Gives you, the notice that you won in litigation, but also it allows potential buyers of your company to recognize that the rest of your portfolio could also be valuable, because there's no greater way I've found to have proof positive, to have history on your side. When we file provisionals for our clients, which we do in the thousands, we have about an 85% chance of getting through the patent office. It's because of that proof that companies come to us to actually get their patents through the patent office. Well, imagine if you had successful patent litigations. By definition, the rest of your patents may have that track record because you've shown you know what you're doing. And the last one is an ROI for enforcing is to develop the business skill of IP litigation. What do I mean by that? So I get to talk to a lot of CEOs during the week of companies who are all sort of interested in patent services, I guess. When I talked about, I have 50 services in IP Capital that I use, and I get to talk about lots of things. But every once in a while, I'll talk to a CEO who appears to be almost like they have this knowledge about patents that most CEOs don't. And the more I talk to them about the business value, they start bringing up things like, claims, inter partes review, the Markman hearing, witnesses and evidence and things like that. And then I recognize that this CEO has superior knowledge about IP. Being through a litigation and winning directly gives that CEO the experience of what the next IP is going to be all about and reasons for it. So it's a unique skill. So if you get to enforce your patents, you will learn a unique skill as a CEO or executive that most won't have. There are not that many litigations per year, and most companies don't get involved in them. If you get that experience, you will really be heads above in terms of overall, useful experience for IP. Now, I promised you that we would have some other thoughts that may impact your decision about enforcing patents. And these are kind of different thoughts. So one thought is, and I almost ended with this in the last topic, is you'll learn how to create better patents. Just by going through the process, you'll learn how patent claims get whittled down through the Markman and why, which may mean that you're going to do better prior art searches. You're going to have a various patent strategy of more smaller patents versus one big patent, omnibus patent. There's so many things you can learn through that process. You'll learn about the devil's advocate process of inventing around, because when you're going to litigate your patents, you'll actually attend sessions with counsel or professionals that will help you invent around the patents, because if your patents are easy to invent around, you might decide not to litigate. So you're going to learn a lot of stuff, which is going to improve your patents, the ones that come after. Another thought is that you may settle once and for all the discussion about how valuable your patents are. I mean, this happens a lot of times in companies with the CFO, the CEO, the board. People say, why are we spending this time and money on patents? Well, winning a litigation is one way to justify this once and for all. Another thought is that if you are an executive bringing the possibility of litigation to a board, you force that board or management to be material, to make a material decision. So be ready to inform the decision makers and investors about litigation, but recognize it's one of the largest business decisions you may ever make, because the risks are so high, the gain is potentially so high as well. So do your homework. Another thought is you may have continuations of your patent that are not yet allowed. You may decide to wait until these continuations are allowed in order to do litigation, because you stand a better chance. As a matter of fact, if you litigate, you may find through the process of litigation, you'll do some continuations as it's going on to strengthen your patent position. Some other thoughts, you might proceed with the patent litigation only if you can find litigation financing. So that's a kind of interesting rationale that should be the topic of a whole podcast, how to get litigation financing. Because I've been involved in so many of these that it turns out that when you get litigation financing, and in one case, we just had 16 of our patents from one of our clients we worked with basically have complete 100% litigation financing, including attorney's expenses. that certainly tells you that investors who have done their homework and lawyers think that you've got a really good portfolio. So sometimes you think about patent litigation, let me ask the question, is it good enough to be financed? Another thought is that you may recognize that patent litigation could be done at the ITC, the International Trade Office, because having someone ship a product from outside the US to the US, you can litigate them and bar them at the ITC from shipping their product in. And that might be an easier win that stops them from shipping product into the US or modifying their products, as was recently happened with Apple and Massimo, where Apple had to take out some key feature of their Apple Watch. You see, if you file patents in the US but litigate in the US and not use the ITC, it's going to be harder. It's going to take longer. It's going to be more expensive, etc. So sometimes another thought is ITC available to you versus just filing and getting patents issued and litigating in the US. Another thought is, and this is kind of cool, you can litigate, and the defendant wouldn't know this, but the reason why you're litigating is to actually settle early. You go through the process of Markman, you subpoena evidence, and then you just stop. So you just get what you need without going all the way through this, and you may get an early settlement. There are these entities that are called micro litigators, and they're in business to litigate to get an early settlement. So that's just another thought. Another thought is you may litigate just to get information from the company, your competitor, but not go to trial. Another thought is, remember I talked about how much time it's going to take you if you're involved in litigation? Another thought is you may litigate for no other reason than to cause the defendant to lose focus. And that has happened. As a matter of fact, this is a really interesting strategy for large companies. When they sue small companies, the large companies mentally, they're not mentally engaged in it. They're just litigating against you. It's not emotional. It's just a business decision. It drives a small company of 40, 50 employees with all that stress nuts. So you may litigate just with the idea to cause a defendant to lose focus. Here's another thought. You may litigate for a larger cause, meaning you're doing it for the strategy move of being noticed so that you can get a higher valuation or force an M&A. There's so many other thoughts I have about litigation that weaves itself into strategy. I could probably do 2 podcasts on other thoughts surrounding litigation, but at least I'd start this. So let's wrap up. Okay, we talked about topic number 1, 10 things to do first. Things to take action, like evidence of use, doing an inter partes review, establishing good relationships with the name inventor, understanding the judge, the venue, title. We also talked about understanding the competitor, how sophisticated they are. There's certainly some things you want to do first. As I mentioned, there's a lot of things you might want to do first, but I just want to give at least 10 that got the process going. If you're considering litigation, consider having some experts come in and sort of do some housekeeping to get you to understand what should you do first before you even start. Then we jump to topic number 2, which is reasons for enforcing your patents. We talked about different reasons like, legal obligation, latches, and things like that, enforcing your market share, trying to get revenues through settlements. Also emphasizing the way to stop copycats is, enforcing your patents. Also, there's many strategic reasons like extracting know-how or trade secrets from the defendant, or even understanding how to set yourself up for future negotiations and agreements, improving your valuation. So there's a lot of reasons, top reasons for enforcing your patents. But just like there's another side to the coin, we did talk about some top reasons for not enforcing your patents, which, as I said before, is something that I almost start with most of my clients when they're considering it. The risk is you lose. The risk is you lose a lot of money too. The risk is that you have a weakened IP position because you enforced them and maybe your patents got invalidated. It also highlights the danger of counterclaims. It's also triggering an arms race, and there's negative PR. And there's all sorts of issues with maybe you've impacted your future M&A, or no investor wants to invest in the lawsuit. So yeah, there's a lot of reasons not to enforce patents. Maybe that's the reason why a lot don't. But certainly there are reasons to enforce patents as well. It's balance. And we talked about topic number 4, which was market and business impact considerations. You see, we discussed the importance of patent enforcement as a way to grow your market share, as a way to open up new revenue opportunities, or as a way maybe to get licensing. Additionally, we talked about you being a leader in innovation and showing it, strengthening your position. Also, we talked about how it gives you added negotiation power or maybe sets you up for an M&A. Also, we talk about how this dominant position is really crucial for you in the market in general for company valuation or investment. So there's a lot of different impacts when you decide to litigate. If you decide not to litigate, none of those impacts are going to occur. So there are some, pretty valuable considerations in the business and market. In topic number 5, we talked about ROI for enforcing. Obviously, it justifies your IP strategy if you win because you paid your expenses and you've generated new revenues. You've got competitors standing down, so you got better market share. We talked about the ROI that your product differentiation features now can help you boost sales by showing that you're the innovator. You may find that enhances customer loyalty because they won't shop around. You may find out that it then makes your overall portfolio even more valuable because investors say if you won one patent case, probably the rest of your portfolio is quality. So it does a lot of things to give you leadership and foster innovation. There's a lot of good reasons. And then in topic number 6, finally, we talked about all sorts of other things that happen when you consider litigation or do it. One is by engaging enforcement activities, you may decide that you're learning so much that you want to get more patents. You may use that information as a way to improve your whole creation of patents. You may find that the board may have to, weigh in on this, and so it becomes a material issue. You may find that through the process of continuations, as you go through litigation, you can continue your patents and have some new issuances to really do better at litigation. Well, you may find that, for instance, getting litigation financing comes up as an opportunity, thus showing you the quality of your patents through litigation financing. You may also find out that there are ways, not through the U.S. courts directly, but through ITC, as a way of stopping competitors of shipping into the U.S. if you have U.S. patents. You may find that this is a great way to do early settlements, or it actually could be used for no other reason than to distract your competitor. Well, you may find out that by doing patent litigation as another thought, that it totally sets you up for your future gameplay for a merger and acquisition or larger investment. Boy, that's a lot. Well, if you like what you heard, please subscribe and like. And come join our blog and Invent Anything. And maybe listen in to our new series on Inventors at Work. This is John Cronin, Invent Anything.